I'm Shanna Welsh-Levin with SoCal Realty Law. I am a real estate attorney of almost 20 years here in Southern California, and I've been the owner of SoCal Realty Law since about 2011. So I am also a licensed real estate broker in the state of California. I don't really do sales, but I use my broker's license for various things like having access to the multiple listing service and having access to zip forms and things like that, all the California Association of Realtor forms and some legal affairs meetings, and I love being a realtor. And then I also have a nonprofit organization called Amicus, which is a 501c3. We build emergency sleeping cabins for women and women with children. We've successfully built a village in El Cajon that is now occupied by 6 women and 3 children, and it's going pretty well so far. So I have been an attorney for over 18 years and a real estate broker for over 16 years. I've authored some legislation, in particular the anti-deficiency statute, and I've been hired in as an expert witness for mortgage advocacy and broker professional standards matters. And I've also taught several MCLE, including one recently for CEB, the North County Bar Association, and the La Jolla Bar Association. So today I want to talk to you about multifamily properties. I want to share some of our unique experiences because many of the SoCal Realty Law clients are owners of multifamily properties, and we'll define what that means in a moment. These owners, these clients have so many interesting things that come up. And so I have some vignettes that you guys may appreciate and some lessons learned. And even if you have a duplex or a triplex, that could still be considered a multifamily property. So there's plenty here for everyone. And if you're just here to get some general information about landlord-tenant issues and landlord-tenant laws, there is a lot here for you as well. So what is multifamily real estate? What is multifamily real estate investing? So the definition of multifamily is a property with 2 or more units on a single parcel of property, which is leased to tenants. So it could be a building with multiple units, or it could be a single property with 2 separate units or 3 separate units, or it could be a duplex as long as the owner does not occupy the duplex. So when there's 2 units, that may not be a multifamily property if the owner is occupying one of the units. But anything more than 2 units generally qualifies as a multifamily property. When you get into properties with more than 4 units, meaning 5 and up, those properties are actually considered commercial properties. Even though the use itself is residential, they are called commercial properties. And when you borrow money against them, you borrow a commercial loan. And those are always considered multifamily. Multifamily homes can be leveraged to generate a great deal of income and to be a very excellent investment for a person who is building their estate or for companies who are building a portfolio. And so we have a huge variety of different kinds of portfolios for multifamily properties. You have these smaller properties, and then you have properties where there are 100 units or more than 100 units. And we represent investors who have the whole spectrum of different kinds of properties. But many times an investor will focus on just one particular type. So we'll talk about those kind of decisions and what it looks like to have one kind of multifamily property versus another. And if they are managed appropriately, they can be a tremendous asset. When managed inappropriately or financed inappropriately, they can be a tremendous risk and a huge loss. So why would someone want to invest in multifamily real estate? There are a lot of different reasons, and it is a popular choice for many investors. One of the main incentives is cash flow. So having versus a single family property. So a lot of this is comparing to just owning a house that's an investment, a house that is being rented out to tenants. Cash flow is more reliable when you have multiple units than when you have a single family, because if one tenant stops paying, you still have others that continue to pay, versus a single family where if they stop paying, you have zero income left. So more tenants will help offset the risk of losing a tenant or having that vacancy. There's also a better profit margin generally for a multifamily property. So when you have single family residences, each one has its own roof. If you have a multifamily building, that building itself may have only one roof. So let's say you own 3 single family properties and 3 roofs. You have to pay separately to replace all of those roofs or to fix all of those roofs, versus in your multifamily building, you just have one roof that you have to pay to replace. It may be bigger, it may be more expensive just for that single roof, but at least it's only one instead of 3. You get the idea. The rent itself, if you divide out the rent versus the different kinds of repairs that are required, there is more rent per square foot to offset expenses for owning and operating and maintaining multifamily structures if they are all in the same building. If you've got 3 units on a single parcel that are more like having 3 single family units, then all that calculation changes. Multifamily properties are known to appreciate faster than single family investments and be more resilient to shifts in the economy over the long term. They're more of an anchor because they're anchored to the rents and to the need for people to occupy them. It's more likely that they will remain occupied through a downturn in the economy. And then so going back to the profit margin and the cost of maintaining them, when you have the multifamily properties, you can do larger projects, and then you can finance them through a refinance or through, other kinds of borrowing tools. So that if you have to replace all of the windows in the building, you can refinance once, do all of the windows as one single project, which ultimately costs less than having to do those projects in multiple different locations and multiple different single family properties. But when doing those kinds of projects, it's extremely important for the management or the property owner to make sure to use licensed contractors and obtain permits, because the larger the property, the more it becomes a target for different kinds of actions, like tenants who might report the property for code violations or for failing to obtain proper permits. So with regard to the lower risk, we want to say that the multifamily real estate investment is a lower risk with faster appreciation. Why would it be a lower risk? Didn't I just say a minute ago that it could be a higher risk? It could be a greater loss. Well, it's because we call it a lower risk because multifamily properties are less likely to be impacted by the changes in the economy or local market conditions. Apartment rents are typically less expensive than single family rents, where, if you rent a house with a yard and you get the whole house to yourself with the garage and everything, the rental for that kind of house, if it's a 2-bedroom house, would typically be more than a 2-bedroom apartment. And so when there's a recession and people lose their jobs, people may still be likely to keep their apartment homes and continue to pay rent. However, people who are in the more expensive single family homes might consider downsizing to get lower rent to have the same number of basic bedrooms and bathrooms than as they have in the single family. So fewer loans. Now, simple math. If you have 10 units in a single building, you would generally have one loan against that building, or maybe 2. But, just the loan covers the entire building. If you are investing in single family homes and you have 10 of them, you could have up to 10 different loans on those properties. And getting loans that are covered by multiple single family residences is not common. That is done in certain cases, but it's not common for someone to borrow a loan that's secured by multiple single family residences. One example of financing, a difference between financing multifamily real estate versus single family, is that if the property is more than 4 units, it's considered a commercial property. So oftentimes commercial lenders want to make sure that the property is owned by an entity. They want the owner to put the property into an LLC and to form an LLC before the loan is made. And we've done these for our clients where, they were getting a very large commercial loan so that they could do a remodel project on their, 20-unit property. And we had to suddenly create the entity for them. But the entity that was recommended or desired by the lender was an LLC, and tax advice. Now, I can't give tax advice, and really, I forgot my disclaimer. None of this is considered individual advice to you or to any particular situation. This is not to be considered legal advice or tax advice. This is only general information about landlord-tenant laws and multifamily properties. I have heard the tax advice that an LLC is not a good entity to receive income through in the state of California because of the way that it's taxed. And so I have heard the recommendation that even though a property may be held in an LLC, the landlord is recommended to create an S corp as well in order to run the income through it for tax reasons. And that seems overly complicated to me, but under certain circumstances, that is what's recommended. So there are some complications there. So some issues unique to multifamily real estate, in addition to some of the financing issues that I just mentioned, resident property managers can be used. And there are different kinds of management. Self-managed property is where the owner manages it themselves. Property management companies are companies that are third parties that are licensed by the California Department of Real Estate and do not reside on site, or generally they don't have an office on site. Sometimes they do. Resident property managers are usually an individual who lives on the property, who does not hold a real estate license and is not required to hold a real estate license. And their compensation is generally, at least in part, free rent. But free is never truly free, because as a resident property manager, they are an employee of the owner, and taxes need to be paid, and certain calculations need to be made by your employment attorney to determine that you're in compliance with all of the employment laws that apply. And the same goes for facilities managers. Oftentimes they get, if they're an on-site facilities manager, they get a break on rent in exchange for their duties, and the landlord has to be in compliance with employment law. I have a little bit more on that for you later. We've done a deep dive into those issues with regard to resident property managers, and I have a little bit of advice for multifamily owners who are using resident property managers. I do think it's a good solution, but only if done correctly. Larger scale problems for multifamily real estate, that includes, termite clearing and other maintenance, where the landlord might have to pay to relocate all of the tenants in order to have the work done. And we have handled these situations where all the tenants have to receive notice, they have to sign a hold harmless agreement, and they have to, agree that they'll be in compliance with all the requirements of the contractor who is going to come in and like tent the property for termites. So we handle those kinds of compliance issues to make sure that the landlord understands their risk, and the landlord may also want a hold harmless agreement from the tenants so that, you know, any losses incurred by the tenants while the property is being tented or remodeled are covered. And as I mentioned, the landlords become a target for compliance issues. We've seen tenants creating social groups or community organizations to address things that they don't, that the tenants aren't satisfied with about the property, or to address issues of compliance that they feel the landlord is not in compliance with. And I am 100% supportive of community organizing. I love to do community organizing, but when it's my client who is having their tenants or some organization on behalf of their tenants come after them for compliance issues, these are very stressful, urgent situations. The tenant group can get a hold of the news crews. You know, the news crews start to come out, picketing starts to happen, and so, you know, it becomes a whole situation that we need to make sure the landlord is handling properly, and we like to help with that, or also refer the landlord to the appropriate other professionals to assist. You have a higher likelihood of discrimination claims when you have apartment buildings, and it's easier for tenants to prove discrimination if it's going on, which means when a landlord is treating one unit differently, the tenants in one unit differently than the tenants in 9 other units, and they have no good reason for those differences, then it becomes very easy for tenants to report this to the Department of Fair Employment and Housing, or to file an affirmative action to support the tenant's rights. And so we need to be very careful that landlords and property management companies are treating everyone the same. Legal compliance is generally much more complex for multifamily. So let's get into some of those things. There are some new laws that affect multifamily real estate. We covered those in our last webinar, and I'm going to cover them briefly again. We've got the Tenant Protection Act of 2019. I think we're all pretty much accustomed to this one. It's our rent cap and just cause law, where it's set up where all of the properties in California, residential properties and multifamily properties, are subject to the Tenant Protection Act. But then properties that are not multifamily by definition can claim the exemption from the law. So that's your single family residences and your duplexes that are owner occupied. And then we have other exemptions, like the one where, you know, if the property is less than 15 years old, it's exempt. It gets ultimately very complicated, and we take those on a case-by-case basis. But you can presume that multifamily real estate of 3 or more units will not be exempt from the Tenant Protection Act. Then for short-term residential occupancy laws, these regulations tend to leave the multifamily market at a disadvantage. These regulations are geared toward regulating residential single-family property owners from renting out their homes as Airbnb or condos as Airbnb. And I feel that not a lot of thought was put into protecting the multifamily property owners when these laws were drafted. So using the City of San Diego's ordinance as an example, they limit the number of licenses per parcel and or per owner. So we've found some ways to help our multifamily owners, clients, to get around those restrictions so that they can get more of those short-term residential occupancy licenses by drafting sublease agreements and by kind of distributing the way that it's structured so that they can get licenses for more units. And if you're curious about that, I'm happy to explain that a little bit more. But it's a case-by-case basis situation. Then we have the Chula Vista ordinance that becomes effective next week. And hopefully you're prepared. We've started preparing all of our notices to comply with that as of months ago. And then the city of San Diego is proposing changes. I have not been able to find the proposal on the agenda yet this year. I'm not sure if I'm missing it. So I'm not sure what the proposed changes are as of yet. I do have some of those details on a slide that's coming up. So just really quick, the Chula Vista Municipal Code does not apply to properties that do not qualify as multifamily. So the simplest way I can explain it is, if a multifamily property is an investment property containing 2 or more units on a single parcel that are leased to tenants and not owner occupied, the Chula Vista Municipal Code applies to everything else, meaning owner occupied homes, including ADUs, duplexes where the owner resides in one unit at the time that the tenancy is created, the single family residence or condo that's not owner occupied, with certain exceptions. And so this is just a more broken down definition of what is not multifamily. The definition of substantial remodel contained in the Chula Vista Municipal Code specifically puts multifamily owners at a disadvantage. I underlined the section that is disadvantageous. So they put in their definition of substantial remodel that the cost of the improvements, excluding insurance proceeds, land costs, and architectural and engineering fees, is equal to or greater than $40 per square foot of the residential rental unit. So what I just said a couple of slides ago is that the rent per the maintenance expenses for a multifamily property, especially when you have 10 units or lots of units, is spread more evenly because you've got just one roof instead of 10 roofs. You've got just one structure instead of multiple structures. So this limitation on per square foot means that those savings that the multifamily property owners get from being able to do these larger projects may exclude them from this definition of substantial remodel. So it becomes harder to use substantial remodel for terminating tenancies if the remodel is like just the roof. Because if you've got an 8,000 square foot building, $40 per square foot, I mean, you guys can do the math. I'm not going to try to do the math in my head here, but well, okay, let's do the math. 8,000 square feet times $40, that's $320,000. So if you've got 8 1,000 square foot units in a building and you want to replace the roof, you cannot use that substantial remodel to get your tenants out if you wanted to use that as a reason to remove the tenants. It also has this provision where the units have to be vacant for more than 60 days, and a lot of remodel projects don't take that long. So this is tough. This really is, this municipal code. Okay, then we have on the municipal code, Chula Vista Municipal Code, I underlined the 2 differences between properties that are defined as residential rental complex in this code, which are 3 or more rental units, versus ones that are not rental complexes, but are not exempt from the code. So the multifamily owner that has more than 2 units has to offer the tenant you don't have to notify the tenant, but the tenant, if they ask the landlord that they want to come back after the remodel or whatever the issue is done, then the landlord has to give them the right to the future rental offer. And so that's an odd one because it's a little bit vague as I'm trying to explain it to you. Obviously, it's very hard to explain. But if the tenant notifies the landlord that they would like to come back, then the landlord, when the property comes back on the market, has to give them an opportunity to rent the property again. And the rental amount can be the new rental amount. There, increases are permitted. It's the relocation assistance that is also very difficult. So for the multifamily property of 3 or more units, the landlord has to offer 2 times the amount of the rent. But if the U.S. Department of Housing and Urban Development rate is higher than the rent that the tenant is paying for that zip code, you have to offer them the higher amount. And if the tenant is disabled or elderly, then you have to offer 3 times that amount. And this puts any landlord subject to this ordinance in a difficult position to find out whether a tenant is disabled or elderly, because that would require asking about a disability or asking about age, which could be construed by the tenant as somebody discriminating against them. So that's pretty awkward. And these are the 2 items that are just very different for multifamily versus the smaller properties. And then we have the city of San Diego. They are looking to enhance tenant protections and focus on no-fault evictions, relocation assistance, and longer notice periods. We don't really know what this is going to look like, but I suspect it will be particularly disadvantageous to multifamily and offer some exemptions to single-family owners. All right, so some of the difficulties of multifamily investments, we talked about a lot of the advantages, and then we talked about the problems with them being regulated a little more strictly. But in general, I see more tenants causing more problems, compliance problems, social organizing problems, and discrimination claims. So to be more specific, so when there's tenant turnover, if multiple tenants leave at the same time, there's actually a greater risk of loss to the multifamily owner, who generally has higher expenses. If you have a bunch of tenants who are deciding to organize to vacate or organize to stop paying rent due to property conditions, or if the landlord is trying to remove the tenants so that they can do a substantial remodel to the entire property or remove the property from the rental market, and those tenants start fighting back, then we end up having, a very risky situation for the multifamily owner with all of their expenses. If they have multiple discrimination claims, these can be very costly claims to fight, and if the owner has to hire an attorney to assist them, then you can see how that would increase the expenses of the landlord. So then management structures and employment issues can, so we don't recommend that an owner self-manage, but many of them do. It's important to either hire a professional property management company or to appropriately manage a residential property manager. So a professional property management company is a third party that's usually paid a commission or a flat fee, who's not located on site. This can add expenses to the multifamily investment. A resident property manager is usually paid in free rent and creates some employment issues, but is usually a pretty effective and efficient way to manage the property, and also gives the landlord eyes and ears on site at all times, and someone that people can personally go to and personally know, who can intercede in issues before they happen. So for example, a group of tenants were organizing against a landlord and starting to reach out on social media. And instead of being powerless to fight this, the resident property manager was able to bring the people together and try to, mediate their concerns and stop this from happening. The landlord was very distressed that they were becoming the target. Their personal contact information had been obtained by the tenants, and they were being inundated by calls, emails, and social media posts. And in this case, they were able to diffuse some of that attention by addressing things more personally with the tenants through the resident property manager, so that the landlord didn't have to be under direct fire. And so then licensing is not required for the residential property manager. A property management company, a third-party property management company, as opposed to the resident manager, the company has to be licensed by the Department of Real Estate. It's a misdemeanor for a third-party property management company to manage a property without a real estate license. But a resident property manager doesn't have to have one. They don't have to have any special training, although they should. And the only requirements are that the landlord comply with all of the employment issues. And the resident property manager is required to be on site a certain amount of time. There are statutes that regulate this. The Revenue and Tax Code regulates this, as well as other regulations. And so if you're curious about what those requirements are, most resident property managers are on site plenty of time. But in one occasion, the resident property manager was enjoying their free rent and also traveling quite a bit. And when they were traveling, they were out of the property for months at a time, and that was not acceptable. That took the landlord out of compliance, and therefore, he had to step in and do some of the management himself. It's also very important that with a resident property manager, they have an employment contract in addition to their lease. And between the lease and the employment contract, they have to reference each other and connect the occupancy of the property to the employment. It can't just be that obviously they're getting free rent because they're the property manager. If the property manager is terminated, the landlord needs to be able to terminate the tenancy right away. Now, it used to be that, it is no longer, but it used to be that when the appropriate contracts were used, if the employment was terminated, the landlord could walk the property manager off of the property upon the termination and then allow them to come back and get their things at a later date. It's my understanding that that's no longer the way the law works, but you don't want to terminate the property manager and then be unable to terminate their tenancy, because, technically they're not supposed to be paying rent, so you can't give them a 3-day notice to pay rent or quit. It becomes very difficult to find a compliant reason under the just cause eviction law to terminate their tenancy. But you don't want to have to let them stay. So you want the termination of their employment to be a reason for termination of the tenancy, and that can be done through the contract. All right, competition in the market and financing issues. So especially in San Diego, there's a ton of competition in the multifamily market. It can be really challenging to find any kind of a good deal. And so the investor needs to be very patient and diligent in keeping an eye out for the right property. And then once they find the right property, they may need a 20% down payment. Commercial loans are unforgiving with regard to down payment. You don't have the nice FHA loans with 3% down. Although there are some multifamily properties where you can get FHA type financing with a lower down payment, but generally you must expect that there will be a larger down payment required and a much larger loan, meaning much larger mortgage payment. So other things relating to financing include creating corporate entities and structures and those entities and structures need to be the appropriate ones for managing the property and for reducing tax liability. And the other things that these corporate structures are used for is to protect the asset and to protect the owner and protect the owner's other assets. So structuring the transaction, structuring the purchase is very important and requires legal advice. It can be done on a case-by-case basis. There is not one general structure that's recommended for all different kinds of properties. During the purchase, the seller is required to provide tenant estoppels. What is a tenant estoppel? So that is a document that is provided to the tenant at first. It's a form. The tenant fills it out and signs it under penalty of perjury. And then the tenant estoppel certificates that are filled out by the tenant are given to the buyer. And on these certificates, the tenants attest to the amount of their rent, any disputes with the landlord, how long they've been there, when was their last lease renewal. And depending on the estoppel form that's used, you can ask for lots of different kinds of information from the tenant. And so the seller has to disclose those, and those are used to finance the property. The seller also has to disclose anything that they know about the property that affects its value and desirability. And then the buyer is recommended to get inspections of the property to identify any deferred maintenance. And all of these things go into the decision about, purchasing this property and how to finance it, and to determine whether they need cash out financing to make immediate improvements to the property. So some things to consider when investing in multifamily properties. First and foremost, the location of the property and how much demand there is in that area for purchasing and selling those properties, and also for tenants who need to rent them. The growth rate can also be determined in many cases, and you want a good positive growth rate for the area. And then the buyer needs to determine their investment criteria. So investment criteria might be generally the number of units that they're looking to manage. What kind of job do they want to do? Do they want to have just a few units, or do they want to have 100 units? How busy do they want to be with this property? What type of tenants? So do we want a building that offers affordable housing? Do we want to buy a building that already has some Section 8 tenants in place? Or are we looking to buy a luxury high-rise that has facilities such as pool and workout room and all of those things that might be provided to all of the tenants? And so with regard to making these decisions, things to consider when investing, be aware that median rents in San Diego have declined in Q4 of 2022. In January, we saw a bit of an increase for the first time since August, so things are starting to come back. And year over year, the rents in San Diego are up about 3.8%, which is a very large increase. So median rents in San Diego for a one bedroom are $1,915, a two bedroom, $2,468. We are fourth in the market in California. San Diego is fourth. We are behind Irvine, which is $3,000 a month for a two bedroom, followed by Fremont, San Jose, and then San Diego, and then Chula Vista. San Francisco and New York City are not anywhere close to us. I believe San Francisco, the Bay Area, is 9th place, and New York is 14th for median rents. So San Francisco and New York City were long considered the most expensive markets, but now they have fallen down on the list, and we are close to the top of the list. I suspect this is because if you know the San Francisco and the New York rental markets pretty well, they're heavily regulated. we in San Diego are seeing quite a bit of an uptick in regulation. And I think we can expect to see more regulation for this very reason, because rents are getting so high. So across the nation, the median rent for a one bedroom is only $1,148 versus our $1,915 rent. Okay, so a quick update. That's all I have for multifamily. A quick update on unlawful detainer litigation. We have a bunch of new and updated forms, in particular our summons. And then the timing for judgments has been just ridiculous, out of this world slow. In order to get a default judgment for a landlord for possession only, meaning we file the eviction, we go through the process, and the tenants ignore us, and so we enter their default, and then we immediately process the paperwork for the judgment. Once the judgment paperwork is in the clerk's hand, it's taking them 4 to 5 weeks just for a possession only. That means no money involved. If you want your default judgment for possession and money, it's taking 4 months. And then it used to be that when we would go to trial, the one advantage to going to trial is that we could get the judgment immediately because we were in front of the judge and we could submit the paperwork right away, and the judge could remember what happened in court and just sign off. But now those post-trial judgments are taking longer than any others. They're taking 5 months because the judge will no longer just sign off on them. So we are encouraging clients who are upset, clearly, and with good reason, upset by this, to send a letter by snail mail to the presiding judge, Michael Smith. Sorry, I believe I have that name correctly. We have the address and the name and everything. We can provide it to you, to send a written letter to the presiding justice to let them know how they've been disadvantaged and harmed by the timelines. You're supposed to have the right to a summary eviction, a quick eviction. And so this is becoming a huge problem for us in San Diego County. All right, so here's some contact information. If you want to get in touch, feel free to reach out. Let us know what you need. I don't think we have too many questions in the chat, but I will check in just a minute, and then I'll open the floor for any other questions. I want to let you know what we can provide to landlords. The services that we provide include general consultation and legal compliance, and lots of referrals to employment attorneys, tax attorneys, CPAs, and any other kind of service-based referrals that are needed. We do lots of termination of tenancy, negotiating with tenants to terminate the tenancy, and communicating with third parties who represent tenants. We offer flat fee eviction services for preparing notices and just getting the unlawful detainer eviction case filed with the court. We also offer flat fees for entering those default judgments and for entering stipulations with the court. And so if the case is going as expected, then we can offer these flat fee services, and I think they're very economical for our clients, and less risk or less uncertainty with the process. We offer flat fee lease preparation using the California Association of Realtors forms, and then we've supported many of our clients through refinance transactions and sale transactions where they needed the transactional support, including entity formation, drafting and obtaining estoppels, drafting addenda, hold harmless agreements, and all of those sorts of things to protect the landlord. We provide maintenance assistance. So, when that property needs to be tenanted and all of those tenants need to be given notification, we can assist with drafting the notices in large groups of notices all at once and getting them served appropriately. We provide sale transactions on an hourly basis and some on a flat fee basis, meaning that there's no commission involved, which can often save a lot of money. And then short-term residential occupancy licensing and structuring, analysis and advising. we have some good strategies available to assist landlords with those. So let us know what you need and feel free to ask any questions